All right, let's now talk about professional licensure. It is also, and when I talk about professional licensure, this is not of a hospital or a healthcare facility, but when I talk about professional licensure, I'm talking about of an individual provider. So physicians have professional licensure, nurses, pharmacists, respiratory therapists, physician assistants, essentially any person who is authorized to provide health care in a state is going to be required to have some type of licensure or certification by a state body. It's again governed by state. There will be state laws on the licensure process. It's implemented by a state agency or a board. For example, it may be the state medical board in Texas. We call it the Texas Medical Board. In Texas, it's called the Texas Board of Nursing, and that is the nursing agency that licenses and then monitors the practice of nurses. There's a board of pharmacy. So again, for every profession, generally there's going to be a licensure board and an agency that implements the state licensure law for that particular profession. The licensure law for an individual profession will set out the requirements for licensure. Those are going to be things like you're going to have to graduated from an accredited medical school or an accredited pharmacy school. You're going to have taken generally an exam that's a certifying or a licensure exam to show that you've met the minimum knowledge requirements for that profession. There may be a requirement for, a certain number of, if you're a physician, they may require that you've done a certain residency or have certification, to hold yourself out as a surgeon versus a general provider. Those types of things will be governed state by state and in the state law, have the requirements for licensure. They'll also, the state agency for a particular profession will regulate the scope of practice and the services. And sometimes we get into, sort of some turf wars or turf battles between the agencies and what what a different profession can do. And again, while this is state by state, in most states, there's not a laundry list of here's the items that a physician can do, here's the items that a nurse, a registered nurse can do, and here are the things that a pharmacist can do. So sometimes there's quite a bit of overlap in what the scope of services are. And this can lead to confusion as to, an allegation that, a nurse is practicing medicine or that a pharmacist is, like outside of their scope, or that a physician is, doing something that's not within their scope of practice in their specialty. So you've got to look at what the state agency for that profession says is within that professional's, whether it's a physician, nurse, pharmacist, respiratory therapist, what's in their scope of service. Prohibit healthcare services by unlicensed persons. And the state act for any particular profession will generally say, for example, if it's the Medical Practice Act, that no unlicensed person, that no one that's not licensed, it's a double negative, but to be provide medical services, you have to be licensed as a physician. And if you're unlicensed as a physician, you cannot provide medical services or hold yourself out as a physician providing medical care. The authorizing body or agency will investigate complaints against its licensed professionals. So if a patient or other individual wants to file a complaint with the medical board, then the medical board will investigate that complaint. The same as, the nursing board, the pharmacy board, respiratory therapy board, they will investigate complaints against their licensed members. And then they will have the authority to discipline incompetent or unethical practitioners that they license. Now, there's some criticism that this restrictive licensing, there's no doubt that it does further the public interest, but there's criticism that it goes too far and that there are some problems. One longstanding problem has been that it's self-regulation, that the majority of members, for example, on the medical board of the state will be physicians. Now, there's, to combat that, there are lay members that will be on the professional board. So by necessity, will generally be made up of members of that profession so that they understand the profession and the requirements and the standards that the professionals they're licensing need to meet. But they will generally have input and certain board members that are members of the lay public or members of other professions that sit on that board. But the reason to have the licensure board and the restrictive licensing that only these licensed professionals can practice our profession is because it's expert knowledge. So, you know, a lay member of our society won't know what should a registered nurse be able to do. Should a registered nurse be able to diagnose medical problems in a patient, or does that belong to, you know, a physician, and a physician has to make that diagnosis? But a registered nurse can do these things as opposed to, you know, a pharmacist can do these things. And so the boards will have members of that profession. The nursing board will have nurses, the medical board will have physicians, the pharmacy board will have primarily pharmacists. And again, those are just examples. So each licensure board will have their professionals set on that board so that there's an understanding of the measures and the standards that their profession needs to be held to. So, you know, again, that brings some criticism with regard to self-regulating. It may limit the choices of both practitioners and patients. We see that in scope creep, where the medical board may say, nope, medical diagnosis can only be made by physicians, and we're not going to let advanced practice professionals, such as advanced nurse practitioners or physician assistants, we're not going to let them make medical diagnosis. Well, in general, many states will allow advanced practice professionals, nurse practitioners, and physician assistants to practice independently in their states without supervision. For example, in Texas, though, we still do have supervision requirements, and every advanced practice professional will have to have a supervising physician. But with a supervising physician, then those advanced practice professionals are able to provide medical diagnoses, prescribe medications, and do things that we're typically seeing more as in the realm of a physician or a medical provider that was licensed as a physician. There may be restrictions on chiropractors, podiatrists, alternative medicine providers as to what their scope can be, because the other professions have essentially said, this is our scope, and now you're infringing on our scope and you're not licensed to do that. So there can be some disagreements, you know, between the professions as to what that, you know, those should be. Now, another criticism is that the licensure board and the restrictive licensing increase the cost of healthcare. It's very costly to have these boards and have these boards monitoring the profession, setting standards, and then reviewing any complaints that come in, doing discipline, and so forth. It's also very costly for each healthcare professional to pay their licensure costs. Every, you know, couple of years, they will have to get relicensed, pay their licensure fees, and, you know, provide additional information and so forth. Generally, there's going to be continuing education requirements also for these healthcare professionals, but all those things improve and speak to the quality of the professionals that are licensed by those boards. Federal law also impacts professional licensure and discipline, not to the extent that state law does, but there are some impacts or you know, some various influences by federal law on professional licensure and discipline within the states. One is payment to Medicaid for healthcare services. There are certain requirements on the licensure that you have to have these certain items or standards for licensure, or you won't have federal payments for the Medicaid services of that state. So the states get, or most states will get large sums of federal money to administer their Medicaid, their state Medicaid within that state for the citizens of that state or the residents of that state. There's also federal requirements going to the payment for providers. Providers, for example, a physician will have a Medicaid or Medicare Medicaid provider number. They also will likely have prescribing requirements and have a DEA, a Drug Enforcement Administration number to be able to provide prescription medications. So those are federal laws whenever we start talking about payment for Medicare, Medicaid, or for prescribing requirements, the DEA numbers, and you to have I guess those the payment structures and the prescribing requirements are set out in federal law rather than state law. So those are things to remember, is that you can't only look to state law for licensure requirements, but you're going to have to look at the impact and some of the practical processes that federal law places on professionals as well. Licensure is subject to due process requirements, and generally we're going to get those due process requirements from the United States Constitution being the ultimate place to look for due process, whether it's procedural due process or substantive due process. There will be that impact on licensure, and that licensure is something that is worked hard for by professionals. They go to school, then they take exams, they maintain their continuing education, they have invested their careers in their licensure. So to remove that licensure, to actively discipline a professional and restrict their licensure or revoke their licensure requires considerable due process. The professional will generally be entitled to know the allegations against them, to have a fair hearing with an unbiased hearing panel, to prevent evidence, to hear evidence, to be represented by attorneys and counsel, and then have a judicial review if there is still an adverse action or a decision to revoke the licensure or restrict that professional's licensure. Anti-discrimination laws will also apply, so that licensure boards cannot build anything into their licensure requirements that would be prohibited by the discriminate or anti-discrimination laws. One thing that may impact that would be disabilities, for example. You cannot have a licensure requirement that says, that for example, a physician must be able to, stand on 2 feet and not be confined to a wheelchair. I mean, that would violate the there would be an argument that would violate the anti-discrimination laws that are basically federal in nature, state as well, but primarily. So these are some of the impacts or the influence that federal law has on our state licensure of professionals. There are cross-border issues that we see, and these can get very complex and be very complicated. One that we see that was enacted is the National Practitioner Data Bank. This is a federal there's a federal law that creates the National Practitioner Data Bank, and it is administered by a federal agency. It's basically the Commission for Health and Human Services that contracts, I think, with a private body to administer the National Practitioner Data Bank. It was established by Congress to improve information sharing between states of practitioner disciplinary actions, staff privilege actions, like medical staff privilege actions in a hospital, and malpractice payments. And the intent was that if you had a bad actor, for example, if you had a physician who had, numerous malpractice, not only malpractice lawsuits against them, but with payouts, there were payments in those malpractice cases, indicating that perhaps they weren't frivolous, and that perhaps the physician had been disciplined by their state licensure agency and had their license restricted, or a hospital had taken action against their privileges in a hospital, maybe revoked their hospital privileges, that they couldn't just move across country to a different state and start up again. That this would be, the National Practitioner Data Bank would be a sharing bank of information, database of information, so that information could be queried state to state and by hospital to hospital, so that you wouldn't have bad actors moving around to avoid one state's disciplinary or licensure requirements. There are reporting requirements for licensure boards, healthcare entities, and insurers, so that information on any disciplinary type action, any restrictions or revocation on a license, any type of adverse action on a hospital privileges, or any payouts in medical malpractice cases would be reported to the National Practitioner Data Bank. And then hospitals that are bringing, at least for their medical staff, if they're bringing medical staff on, they have to do a query every 2 years. So on initial credentialing, the hospital will need to query the National Practitioner Data Bank and then do it every 2 years on reappointment of that physician. So they will query the National Practitioner Data Bank to see if there's information in there that that hospital would need to consider prior to bringing that physician onto their medical staff. Telemedicine and interstate practice is also a very complex area because, again, if you'll remember, licensure is state by state. So generally, a practitioner must be licensed in the state where the patient is located. Now, most state licensure laws will have some built-in exceptions for episodic care, consultations, so that maybe if there's a neurosurgeon in let's say there's, Texas and Oklahoma are near each other. Let's say that there's a neurosurgeon in Oklahoma that has particular expertise in, one area of the brain and, type of surgery that might be doing. Then a neurosurgeon in Texas could consult that neurosurgeon in Oklahoma for a specific patient case, and the Oklahoma neurosurgeon could consult. So generally there's going to be some exceptions for those types of episodic care and consultations. There may be states that have, this presents a lot of problems for telemedicine, because for telemedicine to fully work and to meet the goals and the intent of telemedicine, which is to provide more access to medical care to more specialized practitioners and providers with expertise, let's open it up via telemedicine. We can go on the screen and you can be seen, I live in Texas, but I can be seen by, a specialist in Boston or New York City or Los Angeles or wherever that person may be practicing with that expertise. But there's problems there if I'm located in Texas and those physicians are located in another state and they don't have a Texas license. Many states will prohibit that type of consultation. There can be a special purpose license for telemedicine, and I think 20 some odd states have special purpose license. And then there's some move towards compact licensure. Physician licensure hasn't done this yet, but nurse licensure has. So again, I'm a licensed nurse in the state of Texas, and I have a compact license. And so if there are other states that are in a compact with Texas, and they're all joined into this compact, they have the same type of licensure requirements, and they will recognize, if you will, each other state license. So it's a type of reciprocity, and physicians in some states may be able to get reciprocity in another state, but typically there will be certain requirements. For example, in Texas, even if they have reciprocity for licensure with a physician licensed in another state, then Texas is going to require them to come in and take the Texas medical jurisprudence exam and have some additional requirements before they can get licensed in this state. So they may not have to go through the entire full-blown requirements for licensure in Texas, but they will still have to meet the requirements that the Texas licensure statute for physicians says they will have to meet, and that the Texas Medical Board imposes. So, various issues with telemedicine and interstate practice. Again, another impact from the COVID-19 response was to open up and to loosen some of these restrictions on telemedicine, so that more providers would be available to consult with more patients across state lines and make telemedicine a tool for treating COVID-19 or coronavirus patients. So we'll see whether after the COVID-19 response is up, and hopefully one of these days, I mean, when and if a vaccine is developed, maybe we can return to normal and outside of the COVID-19 response. But then we'll look to see, well, all the restrictions that were loosened for all of these different licensures and requirements on providers, whether they be hospitals or professionals state by state? Do we go back to the way those were? Do we leave them without the restrictions that they had previously? So that remains to be seen, and we'll see what happens with that. Okay, so we've talked some about external facility controls, licensure for professionals, and some of the impacts of the federal government. Let's look at internal facility controls and what each hospital or healthcare facility will do to have certain quality controls of the individuals practicing within that facility. One area of those internal facility controls will be medical staff and medical staff peer review. So any physician that comes onto the medical staff, physician or other provider, and depending state by state as to what the medical staff may be opened up to. It can be medical dental staff. The medical dental staff may also allow advanced practice professionals, nurse practitioners, and PAs to be on their staff. So that differs state by state and also hospital by hospital. But let's just keep it as a good example as to the medical staff. If we're talking about physicians, that will have credentialing. So on initial appointment, a physician will have to fill out their application for initial appointment. They will have to show that they graduated from an accredited school, that they're licensed in that state, that they have their DEA numbers, that they've got their, Medicare, Medicaid provider number, that they, had privileges in these hospitals, that they did this residency, all kinds of information that the hospital will gather and look at. And then the hospital will generally have a committee that's made up of other physicians that look at that credentialing information and make a decision on whether that individual physician meets the criteria and the qualifications and the standards set for credentialing within that facility, and for the staff privileges or clinical privileges that physician is asking for. So if it's let's say it's a orthopedic surgeon and they apply for privileges to do spine surgery, then the credentialing committee will look at what past experience does that orthopedic surgeon have in doing spine surgery, because not all orthopedic surgeons do spine surgery. Some do, some don't. They would look at what are your qualifications, what was your education and training, what's your experience been, what problems have you had, or what indicators do you have that we need to see. That happens now if the provider is brought in, initially and they're initially credentialed. That will generally be good for 2 years. And then every 2 years, that physician will have to get reappointed to the medical staff, and they go back through a very similar review of information. It's not quite as thorough as on initial appointment, but they will look to see what's happened within those 2 years, what additional education has that physician received, have they met their continuing medical education requirements, what complaints have they had in this facility. And to look at that, they often look at what we call OPPE, FPPE, and quality indicators. That's ongoing professional practice evaluation, focused professional practice evaluation, and then quality measures or indicators that the medical staff has set for its physicians or members of its medical staff. So it's a very intense and very thorough process that's ongoing in facilities every single day, really. There's going to be, again, there's a department that will be your medical staff office, and it will have, depending on the size of the hospital, anywhere from 1 to, like 10s, 20, 30, 40, members that do nothing but the appointment, reappointment, and then provide all of this information. And then the hospital will have a committee of physicians or providers that look at all of these indicators and all of this material to determine, if the staff privileges are right, if there needs to be discipline and so forth. Sometimes a physician or a provider can fall out based on quality indicators. Okay, we have these, quality indicators for general surgeons, and you have fallen out of what our indicators should be. For example, maybe you have too many cases that have infections. So we're going to look to see what your quality indicators are and determine if there needs to be some change in your practice. If that change is bad enough, it could lead to a review for an adverse action. Or there could be other, recommendations that are put into place before you get to an adverse action. An adverse action can also be a recommendation that comes in to the committees that review medical staff privileges, that looks, and oftentimes that's the MEC or medical executive committee or other, it depends on various hospitals what they name their committees. But there could be a request for corrective action that, this physician has had, too many deaths following a particular procedure. So we think you all need to review this. And they may appoint a committee, and that committee will look at it. And if the committee says, yes, this is a problem, we think the physician doesn't have the skills, or, they need to get some additional education or whatever, and they want to restrict those privileges, then there's going to be a definition in those medical staff bylaws as to what may become an adverse action. Generally speaking, it's any action that may affect, and this is in part of the federal, laws, and in that National Practitioner Data Bank, that same law sets out adverse actions that have to be reported to the data bank. So in there, an adverse action would be anything that limits or restricts a practitioner's practice for more than 30 days. It doesn't have to be that. If it's a revocation of their privileges, then that's automatically an adverse action. Obviously, a revocation would restrict their privileges. But if you have, for example, a summary suspension where the physician can't practice at all, then that's an adverse action. Anytime there's an adverse action against someone with medical staff membership, then there's going to be due process requirements in a fair hearing. It's similar to the state process, so that you have, you can't just take away this person's livelihood that they've worked so hard for without due process. And there's reasons for that, so that there's, to guard against antitrust and economic credentialing. So physicians that, are all in one specialty can't say, oh, there's too many of us already, and so our patient load is too light. We need to keep all these patients for ourselves, so we're not going to credential any more people of our specialty into this hospital. You can't do that. That's economic credentialing. It would not be due process for the person who wants to come in and have privileges in that hospital. So all those type of requirements are going to be set out in the medical staff bylaws, and it's also going to set out what the due process is, or the fair hearing requirements are for any provider, any physician that has an adverse action against them. They will have a hearing. It's got to be by an unbiased hearing panel. There's going to be certain requirements. I mean, and again, that may be hospital to hospital dependent, but in general, it may be things like they get to certainly have fair notice, a time to prepare for the hearing, to present their information and evidence, to know the evidence against them, to be represented by an attorney, possibly to have experts come in. So it's almost like a mini, very mini, if you will, court hearing, but it's before a hearing panel generally, or at least a hearing officer. And there are all types of due process requirements built in, such as notice and the requirements for representation and so forth. So after the due process requirements have been done, there's been a fair hearing. If there remains an adverse action against the physician, then they can have a cause of action and bring that hospital, or even the credentialing body, to court and say they did this unfairly. When that occurs in a medical staff lawsuit or court action over wrongful medical staff actions, then the judicial review is generally limited to what was the due process and what was the fair hearing. Our court systems have been very, very hesitant to second guess the professionals that have been reviewing a particular professional. So let's say if it's a group of physicians in a committee and they're reviewing a physician who had an adverse action, the court's saying, we're judges, we're lawyers, we're not skilled at being a neurosurgeon or an orthopedic surgeon or a family medicine provider. We don't know what that takes. So we're going to have to rely on the professionals in that field who reviewed this person, but we will look to see, did they get due process? Did they have a fair hearing? Was it an unbiased hearing panel? Did both sides get to bring in, information and evidence? So they will look at that process. And generally that's how the judicial review will be. And it's limited to looking at the fair hearing and due process requirements. And then there are also employee controls. So if you'll remember, many providers in a hospital will not be physicians on the medical staff, but they will actually be employees of the hospital. And that generally is going to include nursing, pharmacists, nutritionists, respiratory therapists, various technicians, CAT scan technicians and MRI technicians, and numerous individuals that provide direct patient care. Employee controls will be one, whenever they're hired, to look at their licensure. Are you properly licensed or certified in the state? Have you met the requirements to practice this profession? And then competencies, and they will look at what are the competencies for this profession. So for example, nursing will have competencies that all nurses will be able to do these skills and be able to do these things as a nurse, that you'll know how to administer medications, and you'll know how to start IVs, or whatever the competencies might be. And that if you are a nurse in a specialized area, for example in an ICU, what are the competencies for an ICU nurse? That you've got to know how to titrate drips of various types of dangerous medications. That you've got to know how to take care of a patient on a ventilator. That you have to do all these different competencies. So each profession in the hospital will have various competencies, and they review their professionals. So for example, nurses, the nursing department, the CNO or the chief nursing officer will have individuals that help make sure that competencies are met and complied with. And then there's also peer review. It's a different type of peer review, and it's oftentimes not to the degree and requirements of due process that we see with physician due process and peer review, but nursing may have peer review and have a peer review committee, and there will be some elements of due process. It's generally, again, not the same level of due process for physicians, because physicians aren't employees, and if you'll remember, they require more due process before their privileges can just be terminated. But if you're an employee, depends on the state, but for example, Texas is an employee at will state. So as long as you're not being discriminated against for something wrongfully, then you're an employee at will, and you can be hired and fired at the will of your employer. But if you're a professional, there still may be certain peer review requirements. And so there you will have professionals of your profession looking to see, did you meet the standard of care that we would expect for a nurse in this particular situation? And then that information will generally be relayed onto the nursing licensure board in the state. So we'll have those types of controls on your employees and on your medical staff, in addition to the requirements that are state-based. So you've got your state licensure bodies, and then you have your individual hospitals or facilities that are going to have all types of internal controls on their providers. And all of those things go together to try to make certain that there are qualified, competent providers in each facility providing quality care that we would all hope to find whenever we walk into an institution. So again, those are the types of internal and external traditional types of requirements to assure that there's quality in our states and in our facilities that, statewide. And then starting next week, we'll look to see what are some of the new things that are coming due to electronic medical records and, massive amounts of data on each facility, each provider, the number of infection rates. Those types of things are really changing the way that we look at quality care and patient safety. So we'll talk about that more then. Thank you.